Midway through the matter of Green Charitable Trust. Giving trustees discretionary or broad powers does not mean that there are no limits to those powers. Trustees' actions will be reviewed for abuse of that discretion. The trustee is bound to exercise his discretion honestly and in good faith. As noted by the parties, the liability of the trustee may be limited by terms of the trust instrument. Comerica's and GAP's liability for error, negligence, mistake of judgment, act, or omission as trustees of the charitable trust was limited to actions done in bad faith. This provision is consistent with the common law principle that trustees may not be liable for mere mistakes or errors of judgment where they have acted in good faith and within limits of the law and of the trust. The exculpatory clause does not preclude judicial review or application of the required standard of care. An exculpatory clause generally is not considered to reduce or enlarge the standard of care required of the trustee in administering the trust, but acts to relieve a trustee of personal liability under stated circumstances. It will not generally be construed to mean that the trustee is not accountable to anyone for his actions. A trust implies an equitable duty to act for the benefit of the beneficiary, and an all-inclusive exculpatory clause would connote either that there was no enforceable duty owed the beneficiary or that there was no remedy for a breach of duty, even if the breach was found to be unconscionable. The bad faith standard used in the Green Trust has not been defined in the trust context in Michigan. However, the principle has been applied in trust situations in evaluating a trustee's diligence, honesty, and good faith. In the insurance context, bad faith has been defined as arbitrary, reckless, indifferent, or intentional disregard for the interests of a person owed the duty. And citation 1986 Commercial Union Insurance Company versus Liberty Mutual. Bad faith is not a specific act in itself, but defines the character or quality of the party's actions. In its presence, as with a determination that a trustee has violated his duty to the trust, depends on the facts of the individual case. Specific duties of trustees include keeping the beneficiaries reasonably informed of the trust and its administration. And that is a statute in Michigan. In the context of the sale of Section 700.814, in the context of the sale of real property, there is an obligation to seek the highest price obtainable. The entire circumstances of the case will be considered in reviewing a contested sale. That the price realized at the sale was at or above the appraised value does not necessarily indicate that the best price was obtained. The duty to obtain the best price has been expanded upon in other jurisdictions to specifically include consideration of the factors noted by the probate court, the determination of fair market value, proper marketing of the property, and the adequacy of the price obtained. The parties have referred us to a number of cases from other courts of which Allard versus Pacific National Bank, a Washington case, is strikingly similar to our situation. In Allard, this is in another state, so it's not controlling, it's persuasive case law. And the Court of Washington affirmed in a...
What, you want me to take it?
Was that the cat? No.
That's her water bowl. I'm just listening.
Court of Washington affirmed defining that the trustee had breached its fiduciary duties in its management of the sale of real property located in downtown Seattle, the sole asset of the trust. The beneficiaries argued a breach of duty based on the trustee's failure to inform them of the sale and failure to either obtain an independent appraisal or place the property on the open market prior to the sale. Both occurred here. The Washington court found the trustee must inform beneficiaries of all material facts in connection with the non-routine transaction, which significantly affects the trust estate and the interests of the beneficiaries prior to the transaction taking place. Allard, Supra, 99, Washington 2D, blah, blah. That's a citation for the case. This duty is based on the generally recognized principle that the beneficiaries must know how the estate is managed in order that they may hold the trustee to proper standards of care and honesty, and obtain the benefits to which they are entitled. In Allard, there was one offering made for the property by a leaseholder who had a right of first refusal. The court found that at a minimum, beneficiaries had a right to know of the offer prior to the sale to give them the opportunity to outbid the leaseholder. We agree with Allard Court that this duty, especially in the instant case where the most valuable asset was the real property, imposed on GAF and Comerica the responsibility of informing all the beneficiaries of the impending sale. It is not clear in what capacity as co-trustees and representatives of the beneficiaries, Dean Hairlong and Bishop McGee, were first contacted. However, it is clear that GAF and Comerica had made a specific commitment to keep Dean Hairlong and Bishop McGee informed, and that commitment should have been kept. The probate court did not err in finding that GAF and Comerica breached this duty. We now turn to whether the trustees fulfill their duties in the sale of property. Allard's second issue requiring appraisal or testing the market has been considered in all other jurisdictions as part of the trustee's duty to establish the value of the property offered for sale. Knowledge of value is a basic assurance that any sale of property is fair and just. Factors which have been considered in determining whether adequate efforts were taken to determine value include the existence of a sound appraisal and consultation with competent local real estate people to obtain their expert advice. In general, the question is whether the trustee had done its homework. In the absence of a thorough appraisal, the trustee may establish value by testing the market. So here's some just examples of assessing value, valuation standards. And testing the market is not limited to consideration of offers volunteered by potential buyers. It includes whatever actions may be available to encourage fair, legitimate, and seasonable competition. In Allard, the leaseholder made an initial offer of $139,000. The trustees demanded at least $200,000, and the leaseholder eventually met that price. The trustee's price was apparently based on an internal appraisal by the Trustee-Bank's trust department. However, the court found that by failing to obtain an independent outside appraisal or testing the market to determine what a willing buyer would pay. Can you start here while I check the cat?
I can't read as fast as you. In our case, respondents argue that they had two appraisals to guide them, Matzels and Carson's, but Jaffe, Kirsten, and Madgezils, my glasses are on, testified that Madgezils was not engaged as an appraiser, but as a consultant, applying his input on an appropriate asking price.
Okay, that's it.
Okay.
I'll just say asking price.
Right there at Jaffe.
Thank you.
Do you want me to listen to you? Will that help you?
Jeff
Keep going.
specifically testified that they did not want an appropriate appraisal early on for fear that it would establish a ceiling on the price that could deleteriously affect the manner of selling the property. That Kirsten and Comerica's real estate department had an opinion regarding value is relevant but not determinative. No evidence was presented by Keating as to the basis for his input, nor is there any indication that Kirsten's opinion is equal to a sound and thorough independent appraisal. The full appraisal on the property was done in 1973. The passage of time, as well as the duty of the trustees, indicate that obtaining a sound and thorough appraisal would have been prudent. Nor do the facts indicate that the trustees, in the alternative, had tested the market. Jaffe's reference to not winning the appraisal early on highlights the weakness in crediting the contacts with local developers in early 1983 as part of testing the market. Jaffe testified that these contacts were not for the purpose of soliciting offers which might have helped establish value. There is no indication that these contacts were part of an organized effort to test the market in a manner which would reasonably take the place of a sound and thorough appraisal. The record does not indicate that the trial court clearly erred in finding that the trustees did not fulfill their duty of establishing the value of the property. So, the probate court's next concern was the inadequate marketing of the property. So that's a holding as it relates to the valuation. So the next issue is marketing. Marketing means taking action to bring the property's availability to the attention of a wide spectrum of potential purchasers. From Longwood, looks like Delaware in 1973. There is no one set method of marketing. Rather, the cases indicate that all the circumstances surrounding the sale are considered to determine adequacy. We agree with the Chancery Court of Delaware that what we are looking for is a reasonably aggressive program which men of prudence and intelligence would have followed. Factors which have been considered include advertisement in an appropriate publication, contact with developers, listing a local broker, using for sale signs, showing the property to prospective customers, consultation with local service sources on whether the offer price was the best offer obtainable, canvassing for possible purchasers, wide circulation of brochures, and taking advantage of events such as free publicity to give the notice of sale. In short, we are looking to see if the trustees adopted and followed a comprehensive and thorough plan to ensure that the reasonable and intelligent steps necessary to secure the best possible market price is taken. Lockwood is a citation for that. Again, same case. The record indicates that whatever early contacts with local developers occurred, they were not for the purpose of marketing the property. The indications from Gaff and Kirstein are that these early contacts, along with information received from Hall and Tilton, were an attempt to formulate a plan for the orderly marketing of the property. According to Jaff and Kirstein, it was not until August that the trustees decided on the standard to be applied in selling the property. The distribution of the circular was their only marketing effort. Even assuming that sending out a circular could be sufficient, this method of marketing is suspect in these circumstances. While the trustees were actively considering an offer on less than all the property and for an initial cash payment of $1.5 million, the property was being marketed to the rest of the world in its entirety. At least one potential buyer was told that they needed an initial cash outlay of $4 million. Furthermore, the entire extent of the marketing effort encompassed approximately 20 days, the time between the mailing and acceptance of the Cohen offer. So the marketing was a little flawed and unfair.
Yeah, about 65%.
There were earlier facts given about it. The testimony of Dean Herlung is that he was informed on August 22nd that an interested party would be given 30 days to respond. However, the circular did not indicate a time limit or that it was of the essence. The record indicates that the potential purchasers, such as Robinson, who had previously expressed an interest, were originally told it would be 9 months to a year before offers would be accepted. Other purchasers could easily have accepted the circular as the first step of a long-awaited offering. The general impression we are left with is that the trustees were basically dormant, waiting for offers to be brought to them. Such lack of activity does not indicate that they fulfilled their duty to the trust. The third area considered was the adequacy of the price obtained. So this is a new issue, which I'm going to call issue 3. Third area. While an accurate determination of value gives the trustees a good idea of where the bidding should begin, it does not mean that a higher price may not be available. The entire range of activities and surrounding circumstances are examined to see if the trustees took steps to understand the value and qualities of the property as well as the nature of the market, and then took appropriate steps to secure the maximum price available. A review of the record indicates that the trustees took a number of actions similar to those mentioned in the cases above. Prior to the Cohen offer, there were phone calls to local developers. There was consultation with an appraiser regarding value. Other experts, Hall and Tilton, were consulted. as to the use and potential problems, and at least 2 prospective purchasers, Robertson and Johnson, were contacted. Following the offer, a flyer was widely circulated among those local entities apparently most likely to be interested. If this were a simpler matter of checking off an appropriate number of boxes, it could be argued that the trustees fulfilled their duty. However, in viewing these actions as a whole, we cannot say that these actions amounted to any actual concerted effort to determine and obtain the highest price available. It's not to say that a written or established plan is required, but rather it is to say that individual actions which do not indicate a concerted effort towards understanding and achieving the maximum price are not enough. In the absence of some contemporaneous evidence on the value of the property, the court was forced to consider the appraisals made in 1985 in determining what an adequate price might have been. Both Majols and Proctor testified both appraisals were available. Both respondents and petitioners were diligent in pointing out to the court the respective strengths and weaknesses of the appraisals. We find that, as with any other means for the assessment of damages, an appraisal must establish with a reasonable degree of certainty what an adequate price would have been. However, the law does not require a higher degree of certainty than the nature of the case permits. Given the facts of this case regarding inadequacies of the trustee's actions with regard to the sale, it is not logical to require proof of a known purchaser or the existence of another offer to establish a price. The inadequate marketing in this case virtually precludes such a finding. The court's finding that Proctor's appraisal, which included consideration of the development potential of the property, was more compelling as an indicator of price than Majol's appraisal is not clearly erroneous. That the probate court found the development potential relevant to the worth of the property is not the same as Comerica's argument that the court was requiring the fiduciaries to speculate in risky land ventures. The remaining issue, so they're going to end it there with a little bit of an evaluation of what the trial court determines. The remaining issue issue 4 concerning a trust involves the court's finding that Gaff was involved in a conflict of interest situation which tainted the sale and established his bad faith and self-dealing. We agree that this is not a case of self-dealing because there is no evidence that Gaff was actually a party or that he directly profited from the sale. We have been given no authority for a proposition that whatever indirect interest Gaff may have had in his firm's fees amounts to self-dealing. However, there is evidence of a potential conflict of interest or conflicting loyalties which must be considered. As a trustee, Gaff was bound to consider the interest of a trust as paramount to all others. If other interests would prevent him from making a sound decision from point of view of the trust, the potential conflict of interest exists. It is a fundamental principle that the trustees must display complete loyalty to the interests of the beneficiary to the exclusion of all self-interest or consideration of the interests of third parties. This principle is based on the understanding that a person acting in 2 capacities or in behalf of 2 interests may consciously or unconsciously favor one side over the other. It is not necessary that the trustee gain from the transaction to find disloyalty. And that citation is given Bogert, Trust and Trustees, section 543, page 204. In its desire to guard the highly valuable fiduciary relationship against improper administration, equity deems it better to forbid disloyalty and strike down all disloyal acts rather than to attempt to separate the harmless and the harmful by permitting a trustee to justify his representation of 2 interests. As an attorney, Gaff also had an obligation to use his skills and judgment in representing his client, thereby assuming a position of higher trust and confidence. A lawyer who is also fiduciary bears a doubly high degree of responsibility and accountability. The State Bar Grievance Administrator versus Estes in Michigan. While the Code of Professional Responsibility is not directly an issue in this case, it is relevant in expressing a standard of professional conduct expected of lawyers by which Gaffey may be measured. At the very least, the code puts the attorney on notice that he is to be sensitive to the potential problems accompanying the representation of multiple clients, Canon 5, and that it is his duty to avoid even the appearance of impropriety. The cases cited by Jaffer, his proposition that multiple representation may be valid, are not determinative since in those cases, the parties were fully informed of the nature of the conflict. As noted by the probate court, Dean Herlong and Bishop McGee, as co-trustees, were not fully informed of the extent of Jaffe's past representations of Cohen, nor is it, so this is distinguishable.
Keep reading, you're doing good.
Nor is it clear that they were kept apprised of the extent of his involvement in the Cohen negotiations and eventual sale. Similarly, the beneficiaries are not fully informed. The fact is that Gaff, as a named trustee, as the agent of Comerica, and as the attorney with the law firm representing both the buyer and the seller, had a responsibility to avoid even the appearance of conflict. The record indicates that this multiplicity of his roles created a situation fraught with conflict that could not be avoided by simply withdrawing as trustee for purposes of approving Cohen offer. Jaff's own testimony indicates the difficulty of the position in which he found himself. It is very difficult in these kinds of situations to differentiate the head that you're using as trustee from the head you're using as counsel. After all, you only have one. You have a lot of hats, but you only have one head. The record indicates that even after he committed not to act as a trustee, he was actively involved in the negotiations. And yet he testified that he had declined to act as both attorney for the estate and trustee for the charitable trust. The only party left to represent was Cohen, but Jaff maintains that his firm's representation of the buyer was kept separate from him. We know that Jaff was involved in meetings regarding the adequacy of the offer and that he indicated approval of it to Comerica, as noted by the trial court. Even had the one-page circular been designed to expose the property in its most favorable light to the market, there obviously was no time for any developer to investigate the property, perform soil borings, conduct environmental studies, prepare site plans, have property appraised, and study development costs, let alone prepare a bid. Cohen, on the other hand, had the benefit of the Calvin Hall site plans and Tilton materials and had spent 5 months studying the property before he had Honigman lawyers submit his bid. At the very least, the short time span between the mailing of the circular and the acceptance of the Cohen offer gives the appearance that matters have been manipulated to assure that no other offers will be submitted or considered. Given our earlier finding of the adequacy of sale efforts, we cannot say that Jaff's actions were the fair and adequate dealings of a loyal fiduciary. The court did not clearly err in finding a conflict or in finding that the conflict resulted in the breach of Gaff's duties. However, while it was appropriate for the probate court to consider the Code of Professional Responsibility as indicative of the standard to which Jaff should be held, we find that as holding that he violated the disciplinary rules must be vacated. The appropriate context for the consideration of this type of attorney misconduct appears to be proceedings by the Attorney Discipline Board or an action brought by the aggrieved client. I'm sorry, appears to be, yeah. So this is the wrong forum for that. The probate court's holding on this issue was not a necessary part of the adjudication, and to the extent it may be considered a holding of the court, we vacate it. We further agree, given the facts of this case, that it is clear that Comerica had a responsibility to monitor or in some ways react to Jaff's conflict. Comerica's duty of loyalty applied to Jaff and his firm as Comerica's employees or agents, wherein a trustee allows its agents to pursue their own interests while carrying on trust work, the trustee may be liable to the same extent as the agent. So that sounds like a rule, but I don't have a citation for it, but it sounds like a rule for a holding as it relates to Comerica. On the basis of all of the above, we affirm the trial court's holding that the GAF and Comerica failed in their duties as trustees. Their actions and inactions were not mere negligence or errors in judgment. Their actions clearly in violation of their duties and done with reckless or indifferent disregard of the beneficiary's interests indicate they acted in bad faith and preclude any insulation from liability under the trust exculpatory clause. As to Comerica's liability as a personal representative, by statute, the personal representative stands in a position of confidence and trust with respect to the beneficiaries. Edith Green's will gave Comerica as personal representative the same broad powers it enjoyed as trustee. God, there's too many holdings. But the similar limitation of liability, excluding negligence and mistake of judgment, was specifically made not applicable to a corporate fiduciary such as Comerica. As a fiduciary, Comerica is liable for loss resulting from its negligence in handling the estate and for any misfeasance, malfeasance, or other breach of duty. Sounds like a rule, but I don't have a citation for it. As a fiduciary, this is a whole nother issue because Comerica was the PR for an estate not involved. I mean, completely separate from the trust and its actions as a trustee. For
Yeah,
the
isn't
same
that the conflict
people.
of interest they're talking about?
Well, it's just a whole nother transaction entirely.
Oh.
As a fiduciary, Comerica is held to the same standards. So there's more than one duty here. There's a duty to the trust, and there's a duty to the estate. As
Right,
a
so-
trustee, as a fiduciary, Comerica is held to the same standards regarding the sale of the property as were discussed above. Furthermore, the loyalty rule considered above with regard to JAF applies to all fiduciaries and their agents, not just the trustees. The reasons discussed above also support the court's finding that Comerica is liable for its failure to fulfill the duties as the personal representative. All right, well, what's their holding on that? Yes, as to whether Dean and Bishop were stopped to complain, the general rule is that ratification occurs only where the beneficiary acted in full knowledge of all the facts and not under the influence of misrep, concealment, or other wrong conduct of the trustee. The record supports the probate court's finding that there was no estoppel because their qualified consent was not based on a full disclosure of the facts or the extent of the Jeff Cohn dealings. So there's this issue of estoppel that I'm seeing for the first time. Nor were they fully informed when they signed the Cohen land contract. On the issue of damages, the probate court found Comerica as personal representative and trustee and GAF as trustee jointly and severally liable for their activities in the amount of $1.9 million. There was no finding concerning marital trust, nor did there need to be. Comerica's liability was based on the evaluation of its activities. That Comerica was found liable for its role as trustee of the marital trust does not make its liability in its other roles any less. The same is true for GAF. That GAF was not a trustee or personal representative of the estate is irrelevant to the liability imposed because of his own breach of duty as a trustee of the charitable trust. To carve out identities and liabilities at this stage of the proceeding smacks of the artificial and appears to be an effort to avoid liability rather than define the limits of liability. But finally, both GAF and Comerica asked that they be reinstated as co-trustees and personal representative, removing the fiduciary as a question entrusted to the discretion of the probate court. And that court's decision will not be reserved absent an abuse of discretion. Given the facts of this case, we find no abuse of discretion. So the answer is no. No reinstatement. With the exception of the finding regarding GAF's violation of the Code of Professional Responsibility, which is vacated, the probate court's order is affirmed.